We have the trial and we have sentencing. If they're guilty, they'll come back to court after for the second half of that trial process, and that's called sentencing. And that's where the convicted offenders, friends, family and colleagues can write these, biased letters saying that he might have been doing this, but he's actually a good bloke, or he's a pillar of the community, or he's a dedicated and loving father. And for a victim to have to sit in that courtroom after going through a rigorous trial and thinking they've got justice after a conviction, it's absolutely devastating and it's incredibly dehumanising, and that's why we were inspired to make this change and push for it. At the Your Reference Ain't Relevant campaign, our original ask was to abolish good character references for all convicted child sex offenders, but the New South Wales government has gone one step further and abolished it for all references.
Could you give us some specific examples of some of the most disturbing cases of character references that have been used in sentencing?
One thing that springs to mind is the convicted child sex offender, Paul Frost. He was a former MasterChef contestant and a swimming coach, and during sentencing he had character references that described him as a champion of young people. I mean, he was charged with 43 offences, I believe, for sexually abusing 11 children. And those adult survivors and their families had to sit there in court at sentencing and hear him lauded as a champion of young people. I mean, it's offensive.
There has been some limited criticism of the reform from some lawyers who say that it makes the system less just, that it's taking away some rights of the defendants. What do you say to that?
Well, look, the New South Wales Sentencing Council is a group of 16 members. These are defence lawyers. These are some of the most profound legal scholars and minds that the state and country has to offer. And out of those 16 members, only 2 dissented. Every major reform that we see has faced resistance from parts of the legal profession. It's a system and an institution that is entrenched in tradition. It happened with no-fault divorce. It happened with marital rape that was criminalised. It happened with affirmative consent. And history has shown that discomfort often precedes progress. And after years of review and scrutiny and debate, this reform prevailed because it's evidence-based and it's long overdue. So that's what I would say to the criticism, that an overwhelming majority agreed with this reform.